Welcome to the Thank you, Lance. Welcome to the Know Your Work Rights training for the CARE grant. Thank you for joining us today. We know that the first couple of months of the CARE grant can be a big lift with all the trainings and the administrative pieces that go into the grant program, and we appreciate you making the time today for this training. We have a lot of information to cover in today's presentation. I'll just ask everybody to stay on mute if you are not speaking. We will keep an eye on the chat for any questions that come in, and we'll make sure to address them at the end of the presentation. And any questions that our team cannot answer, we will make sure to follow up after the presentation with everybody and with a full and complete answer to that question. There's a lot of topics we have to get through today, so we may run into an issue or a topic that you have a very specific question on, and our team will do our best to answer and follow up if we can't answer in this session today. And then finally, the slides and the recording will be shared next week through the weekly digest. So do not feel like you need to rush and copy down all of this information. We will be sending that out next week. Okay. Just a disclaimer before we start. This presentation just provides a general information and is not a legal opinion. The New Jersey Department of Labor and Workforce Development has provided this information and related materials as part of the 2024 CARE Grant Program. The presenters, myself, Rebecca, have worked closely with our colleagues at the Department of Labor to keep this information timely and accurate. However, there is often delays between official publication of information and the materials that are developed. The New Jersey Register and the New Jersey Administrative Code remain the official source for any regulatory information published by the Department of Labor. Okay. An agenda for today's call. So we're going to start with a quick overview of wage and hour laws, and then we'll dive deeply into the earned sick leave law, minimum wage, overtime, wage payment, misclassification, and temporary workers' bill of rights, as well as sharing some helpful information on how to file a complaint and other related work rights topics that will be helpful to just have information on, but aren't necessarily funded to be outreach topics for the CARE grant this year. Before we start, it's important just to know that the New Jersey Division of Wage and Hour Compliance enforces New Jersey's labor laws covered in today's presentation. You can see the ones listed here. And then because many of you, next slide, please. Because many of you are working with immigrant communities and people with various legal statuses, we just wanted to emphasize that that these laws protect all workers regardless of their legal status. That the New Jersey Department of Labor employees do not ask about immigration or citizenship and serve all workers regardless of their status. That the New Jersey Department of Labor will not share any information from an investigation with any federal immigration agency unless we are legally required to do so. And an employer cannot withhold payment because an employee does not have a valid social security number or because an employee has not completed a W-4 or an I-9 form. So we'll get into the detail of all the wage and hour laws. But first, I'm going to hand it over to Rebecca, who's going to cover information on our earned sick leave law. So Rebecca.
Thanks, David. I'm really excited to be here to talk to you about New Jersey's earned sick leave law. Most of you have been through a paid family and medical leave presentation. That's for longer term leave, but if you only need a few days at a time, sick time is now the law in New Jersey, and it's for more than just being sick. So we're going to go over a lot of the details of this law. All of this comes from our mysickdays.nj.gov webpage, so you can find that all there as well. And we will get these slides translated into Spanish soon, as well as any other languages that you might need. Just let us know. Okay, so this is just a quick overview, but then I'll go into more details about all these points. Employers must provide employees with up to 40 hours of paid sick time per year, so you can care for yourself or a family member. Employers can provide 40 hours up front, or the employee can earn 1 hour for every 30 hours worked, up to 40 hours. This really applies to like every type of employee, whether you're full-time, part-time, no matter how you're paid, if you're hourly, cash, piece rate, salary, this all applies. And it also applies regardless of immigration status. As David mentioned, we enforce these laws regardless of immigration status. So this is for more than just being sick. It's called paid sick leave, but you can also use it to care for a loved one who has a physical or mental illness, as well as your own. You can use it for your own wellness care, so like your annual doctor's appointment or a dentist appointment. You can use it if you or a loved one is coping with domestic or sexual violence, anything needed to cope. You can use the sick time for that. You can also use it to attend a child's school-related meeting where the parents or guardian's presence is requested by the school, which is something important to note as we're all starting our children's school time now. There's also some limited public health emergency uses, quarantining based on the advice of a healthcare provider or public health authority, as well as to care for children when their school or childcare is closed due to an epidemic. So that was definitely very applicable back during the peak of COVID. Like I said before, you're most likely covered. Employers need to provide earned sick leave to nearly all their employees, no matter how much you work, no matter how you're paid, and regardless of the employer size. So even the smallest employers, say the employer has 3 employees, they are still required to have their employees earn sick time. There's very limited exemptions for the earned sick leave law. So certain union construction workers, whether under a collective bargaining agreement, per diem healthcare workers, public employees who are provided with full pay sick leave under another law, as well as properly classified independent contractors, also sometimes called 1099 workers. We're going to talk about how to be properly classified as an independent contractor later in the presentation. If you're an independent contractor, you're not an employee, so you don't get sick time. But again, you have to be properly classified for that to be effective, or for that to apply. As I mentioned, you can use earned sick leave to provide care for a family member or a loved one. This implies to any biological family, any extended family, chosen family, anyone you consider to be family. The definition is very broad. This is the same definition that we use for family leave insurance, where if you need longer term leave to caregive. Employers must provide written notice to an employee at their time of hire of their earned sick leave, as well as display the earned sick leave poster in a spot that's easily visible and in the languages that the employee needs. David will show where you can find these posters online and where you can request free copies as well. So as I mentioned, you can earn your sick leave 1 hour for every 30 hours worked. Up to 40 hours. The 40 hours is the maximum amount employers are required to provide you. But of course, employers might exceed that and be more generous, but this is like the minimum requirement. Employers might also choose to provide 40 hours of earned sick leave up front at the start of the year, and this way they don't have to keep track of how much time you've earned. That's called advancing leave. So this is just repeated, that's called advancing leave. An employer, if you start in the mid-year, employers can prorate your leave, so give you part of the leave that you would have earned. But then in that case, they're still required to keep track to make sure they're giving you at least 1 hour for every 30 hours worked. Providing reasonable notice could be required. Notice requirements differ depending on the type of leave you need. So for planned leave, so for example, you have a wellness appointment or you know that you have a school appointment coming up, employers can require you to give 7 days advance notice. Only if the employer has stated the notice requirements in advance. There could be restrictions during peak times. Employers might limit leave during busy periods or blackout periods, but they must inform you of these dates. And there's very limited reasons why there might be a blackout period. So for example, like Black Friday in a retail job, they might say you can't use planned leave during that time, but those periods have to be approved and stated clearly ahead of time. If you have unplanned leave, so for example, you wake up with a fever, you didn't know what was happening, you just have to inform your employer as soon as possible. Your employer should pay you your regular hourly rate. So if you had to take a sick day, you should be getting paid the amount you would have gotten if you went in that day. There's some calculations for any non-standard pay, but I won't go into too much detail just to keep us moving. Your employer cannot require documentation for 1 day of sick leave or 2 consecutive days. They can only require you to provide documentation if you take 3 or more days of leave in a row. If your employer is not allowed to ask for documentation, they must assume your reason for taking leave is a valid reason. The only exception, again, is during those predetermined busy periods, but they must let you know about these dates in advance. Employees who use sick time are not required to make up their hours or find coverage. So your employer would have to be the one to find a replacement for your shift if that was necessary if you're taking sick leave. You can choose to make up your hours if you and your employer agree, but they cannot require that. If you have sick leave left over at the end of the benefit year, you may carry up to 40 hours of earned sick leave into the next one. And this way you don't have to like wait to earn it, to use it. Your employer only has to allow you though to use up to 40 hours of leave per benefit year, even if you carried over leave from a prior year. Another option, and some employers do this, is to just pay you out for your unused earned sick leave at the end of the benefit year. So say you have 10 hours of unused earned sick leave left, they might just pay you out and give you your regular rate of pay for those 10 hours at the end. The concept of a benefit year is important to understand. So basically, when we say years in earned sick leave, it's not necessarily a calendar year, though it could be. A benefit year is the period of 12 consecutive months that an employer establishes in which an employee can accrue and use earned sick leave. This can be based on a calendar year for all employees, or sometimes employers might do it individually based on the time an employee is hired. Employers must keep records documenting compliance over the last 5 years. Records must include employee hours worked, any accrued or advanced sick time, any sick time used, paid out, and carried over. And if the Department of Labor requests these records, employers must be ready to provide them. As a reminder, if you need more time for leave, you could potentially be eligible for paid family and medical leave, also known as temporary disability and family leave insurance. These are benefits you apply through for the state for a longer term leave, like weeks or months at a time. I'm going to pass it back over to David now.
Great. And I'm going to take over sharing my screen. Let's do that. Can folks see see the slides? Great. 1 second. Okay. So yeah, thank you, Rebecca, for covering that sort of helpful information about the earned sick leave laws. I will be covering the remainder of the work rights for today's presentation. So I will cover the topics that are, many of these laws are enforced by the New Jersey Department of Labor's Wage and Hour Division. We know many of you have experience with these laws, and this training is to provide the basics on these wage and hour laws that the department enforces so that all grantees have a baseline to start their outreach work. Like as I said, we'll try to address the questions at the end of the presentation. But before we start, I wanted to share some helpful requirements for employers. So employers are required to give notice of rights and display posters in the workplace. In most cases, you have to pay you at least the New Jersey minimum wage and overtime. Employers are also required to pay wages regularly, at least twice a month. They are also required to maintain books and records showing payroll hours and other work information. They are required to follow specific rules for workers under 18 years old, and they have to cooperate with wage and hour investigations. Additionally, employers cannot take illegal deductions from your paycheck, and they cannot retaliate against you for filing a complaint or use your immigration status against you. We'll cover more information, more details on the following slides, but it's also important to note that violations are always also employer's fault, even if the employee agrees to violate the law. For example, if an employee agrees to be paid off the books, the employer is still at fault for engaging in that activity. It's also important to emphasize that your employer cannot violate the law, even with your okay. If an employer breaks the law, you can still file a complaint, even if you agreed to it. Employers do have requirements to share wage and hour information via posters in the workplace. Employers are required to display New Jersey Department of Labor's posters where workers can easily see them. Not displaying required posters is a violation of New Jersey wage and hour law, and you can find the posters at nj.gov/labor/posters, where you can download and print them, or you can request them for free by emailing wage.hour@dol.nj.gov. Okay, so the first topic we're going to dive into is minimum wage. The current minimum wage rate for 2024 is $15.13 for most employers. There are some notable exceptions to the minimum wage law, though. So for seasonal and employers with fewer than 6 employees, the state minimum wage for 2024 is $13.73. For agricultural employers, the state minimum wage is $12.81. And for long-term care facility direct care staff, the minimum wage is $18.13. And of course, employers can pay a higher rate upon hiring if they wish as well. We will cover tipped workers minimum wage on the next slide, but if you want more information about minimum wage, you can find it at nj.gov/labor/minimum wage. Okay, so in 2024, the hourly wage for tip workers must be at least $5.26. So the total earnings, that's hourly wage plus tips, must equal at least the state's minimum wage, though. That's the $15.13 rate. An employer can apply a tip credit, so up to a set amount of the worker's tips towards their minimum wage obligation, though. So in other words, for 2024, employers can count up to $9.87 of an employee's tip towards the state minimum wage. Um, but if total earnings, again, this is tipped workers' minimum wage plus tips, is less than the minimum wage rate per hour, the $15.13, the employer must make up that difference in the employee's wages. And again, you can find more information about the tipped wages at nj.gov/labor/tipped workers. Next topic is overtime. Overtime pay for hourly employees must be 1.5 times regular rate of pay for all hours worked over 40 hours per week. Employers can require employees to work overtime. In that case, employers must pay the correct overtime rate. There are some important exemptions to overtime, though. So salaried employees can be exempt or non-exempt. Just because an employee is salaried or has a title of manager does not mean they are exempt from overtime. Employers can't just say all administrative employees are exempt. They have to follow the rules laid out in the Federal Fair Labor Standards Act to make sure that employees meet the requirements of a specific exemption that an employer wants to claim. The requirements laid out in the Fair Labor Standards Act are that employee is paid on a salary basis, and employees are paid at least a minimum salary threshold, which is currently $844 a week, and that they perform job duties that are job duties of an exemption that the employer wants to claim under the Fair Labor Standards Act. These are administrative, professional, and managerial, and other duties as well. Employees have to meet all these requirements to claim a specific overtime exemption for it to be acceptable. So there's a new USDOL overtime rules that went into effect on July 1. It increased the minimum weekly salary threshold for overtime exemptions. So now more New Jersey workers are covered. So for 2024, it's $844 a week or $43,888 annually. For 2025, it's $1,128 a week or $58,656 annually. And starting in January of 2027, and every 3 years after that, the US DOL will adjust the salary threshold based on updated wage data. Next, there are requirements employers must meet around wage payment. These include notifying employees of rate of pay and regular payday upon hiring, notifying employees of any changes in rate of pay or paydays prior to those changes, and providing each employee with a statement of deductions for each pay period, and paying wages on regular paydays. Here is an example of a pay stub. You can see deductions in the bottom left column. This slide just shows how deductions are listed on a pay stub, and workers should review this column to see an example of what normal deductions should be. As I mentioned earlier, there are record-keeping requirements for employers. This includes employers need to keep daily and weekly records of the exact total hours workers work each week within a week, each day and within each week. For most laws, employers need to keep records for 6 years. And we recommend that workers keep their own records. This can be helpful if they need to file a complaint. And a helpful resource is the US DOL time tracking app. It's an app that helps track regular work hours, break times, and overtime hours as well. Records um, there are records to include the following information. So records that employers have to keep must include name of employee, address, rate of pay, gross and net wages, itemized deductions, mode of payment, check date or payment date, and then earned or used sick leave hours. The next topic is classification or misclassification. So correctly classified independent contractors, as Rebecca mentioned, are not eligible for earned sick leave, but also TDI FLI benefits and unemployment insurance benefits. It's not uncommon for employers to illegally classify employees as independent contractors, sometimes referred to as 1099 employees. They may also be paid off the books as well. Workers are not at fault if an employer misclassifies them, but they could be deprived of work rights and other benefits. New Jersey uses what is called the ABC test to determine whether a worker is an employee. If you perform a service and are paid, you are presumed to be an employee. There are very limited circumstances which a worker is considered an independent contractor. Some of these are some signs that may indicate a worker is misclassified as an independent contractor. So their employer directs or controls their work, providing training, providing tools or supplies to do their job, and has specific responsibilities. Their work is similar or the same to work being done by the business where they're working, or they work for only one employer. So those are some signs that may indicate a worker is misclassified as an independent contractor. To learn more about the ABC test, including a full description of it, you can visit the myworkrights.nj.gov. Under New Jersey law, if an employee is misclassified as an independent contractor, they are entitled to back pay for unpaid minimum wage, overtime, failure to pay prevailing wage, and other payments due under the wage and hour laws, including reimbursement for any illegal deductions. They are entitled to rights guaranteed to employees like TDI FLI and earned sick leave. Workers can also be awarded up to 5% of the worker's gross earnings over the past 12 months as a penalty for the illegal practice of misclassification. Next, there is the Temporary Workers Bill of Rights. We will be providing a full and comprehensive training on the Temporary Workers Bill of Rights at the Quarter 1 meeting. This is a new law enacted, and our team is fleshing out a full training on this just so we can bring everybody up to speed on the different provisions of the law and how uh, the New Jersey Department of Labor is implementing it. But for now, we just want to highlight some of the important provisions of the law so that you all can begin to do your outreach work. So this is a law that gives new rights to many temporary workers. These rights apply if you work for a temporary health service firm and do certain jobs for client companies. Some of the most common jobs covered by the law are temporary warehouse workers, moving and maintenance jobs, and construction, but there are many more, and you can find them on the nj.gov/labor/temp workers website. The new rights include assignment information in a worker's language that they speak, equal pay and benefits as client company employees doing the same or very similar work, no fees for transportation or check cashing, and paid hours if your assignment is canceled or moved. And again, you can find more details about the Temporary Workers Bill of Rights, including all the covered employee types of temp employees at nj.gov/labor/temp workers. Again, while not technically part of the work rights outreach under the CARE grant, a similar bill to the Temporary Workers Bill of Rights was recently enacted, known as the Domestic Workers Bill of Rights. So domestic workers have new protections under this bill. Domestic workers provide in-house services to private households, including childcare, house cleaning, care for elderly or disabled individuals, and cooking. And their new rights include contracts in their language, breaks depending on how long that somebody works, privacy in a personal space and private communication, new health and safety standards, and protections from discrimination under the New Jersey law against discrimination. And again, more information on this bill and these rights can be found at nj.gov/labor/domestic workers. Other recent changes in wage and hour law that may be helpful to know as you engage in outreach are around the child labor laws. So effective June 2023, workers need to complete working papers online. Child workers, where minors under the age of 18 need to complete working papers online at myworkingpapers.nj.gov. Previously, they received working papers through their school district, and now it is handled by the New Jersey Department of Labor. And before the job starts, a minor and employers must register at that website, and a caregiver can approve or deny the working papers. Um, Retaliation. So there are laws to protect workers accessing their rights mentioned throughout the presentation. It is important to note that it is unlawful for an employer to retaliate against a worker for asserting their workplace rights. And retaliation could look like a number of things, and that includes, but is not limited to, sorry, I got lost my place. Being fired, reducing salary, increasing oversight on job duties, changing workplace responsibilities, and excluding worker from meetings. If retaliation occurs, a worker has the right to take private legal action. Additionally, employers may not retaliate against a worker for filing a complaint with the Department of Labor. It is against the law. Employers that break the law can face fines and penalties. More information about that can be found at myworkrights.nj.gov. And additionally, a new law was recently signed, and employers face increased penalties if they disclose or threaten to disclose a worker's immigration status to conceal their violations of work rights and other laws. The New Jersey Wage Theft Act. So, employees can sue employers for wage violations. Employee can recover attorney fees and up to 200% of liquidated damages. Employers can face increased fines and penalties, and there is a presumptive liability. So if an employer does not keep proper records, they have to prove that they did not break the rules. The New Jersey Department of Labor will presume the employee's claims are correct if the employer does not have records. If your work rights are violated, workers can file a complaint with the New Jersey Department of Labor. Filing a complaint is free of charge. The New Jersey Department of Labor can investigate claims going back 6 years from the date you filed, and they can be filed online or print and via paper. And you can find the form at nj.gov/labor/file. And then there's the address here where it could be sent to, and a phone call where you can call to ask more information. Um, okay, so it's important to remind folks that care grantees cannot utilize care funds to file a complaint on behalf of a worker or represent a worker in wage proceedings, but you may use care grant funds to inform them about their rights, how to file, and assist them with filing. You just can't represent them um, when you can't file a complaint on their behalf or represent them in proceedings. Some helpful tips for filing a complaint include a trusted person may file on behalf or help you file. A group of employees must file separate complaints. Um, and other tips are answer questions accurately and submit copies, not originals, of all relevant documents. And that you may be asked to provide additional details, such as employer information and hours worked. And farm workers, if they're filing a complaint, should email farms@dol.nj.gov to tell us you filed and to get more help. So after filing, if you file online, you'll receive a confirmation number via email within 10 days. Paper complaints do not receive a confirmation number, though. A complaint may be assigned to an investigator, referred to wage collection proceedings handled by mail or a meeting with a DOL representative, or in some cases referred to another government agency. You'll be contacted if we do not accept your complaint, though. You can check wagehour.nj.gov with your confirmation number to see where your complaint was referred. Allow 30 days after the filing for this to be updated, though. In some situations, we may ask your written permission to share your identity or information you have provided with your employer, and you may decline that, and we will not share said information. And again, this process could take weeks or months. If your an employer owes you money, they may pay you directly or through us. Payment is not guaranteed. If we determine you are not owed money, you can appeal, and you can learn more about the appeals process at nj.gov/labor/wage appeal. The New Jersey Department of Labor does not inquire about citizenship and serves all workers, regardless of immigration status. So this is information about confidentiality and filing anonymously. In 2020, the New Jersey Department of Labor strengthened its confidentiality regulations, ensuring that your identity is kept confidential as confidential as the law will allow us. The New Jersey Department of Labor will not share any of your information, including with immigration agencies, unless legally required to do so. There are limited situations where the New Jersey Department of Labor is permitted to disclose identifying information. For instance, if it's necessary to enforce New Jersey Department of Labor laws, or if it is required by a judge or a government agency. Law enforcement agents must provide a signed request and a warrant and certify that they will keep the identity information confidential. We cannot provide identifying information to government agencies if a complaint is filed against said agency, though. Um, in some cases, your employer may be contacted. We may ask for your written permission to share your identity or other information provided with your employer. If you decline, we will not disclose it, though. Except in very limited circumstances, we will not inform your employer that you have filed a complaint with the Department of Labor. So just to reiterate, during an investigation, the Department of Labor will not reveal reveal a worker's identity without permission, share a worker's personal identifiable information such as name, social security number, or birth date, disclose what caused us to open an investigation with your employer, or share personal information with immigration authorities unless we are legally required to do so. Your identity, filing anonymously. Your identity is kept confidential to the greatest extent allowable under law. New Jersey Department of Labor will not share any information, including with immigration agencies, unless required to do so, as I mentioned. To file anonymously, file by mail or fax, write anonymous in the name section of the complaint form and leave the address blank. You won't receive any information about your complaint or be able to check on its status, though. So immigration relief. So depending on an immigrant worker situation, DOL, New Jersey Department of Labor may be able to offer assistance with immigration relief. This can include statements of interest. So for workers who report work rights violations, the New Jersey Department of Labor can issue statements of interest to the Federal Department of Homeland Security in support of a deferred action application. Can also support with UNT visa certification. So the New Jersey Department of Labor can issue a certification in support of UT visa applications, or UT visas are used for victims of certain crimes and human trafficking. So to learn more about how the New Jersey Department of Labor can support immigrant workers with their immigration relief process, you can visit nj.gov/labor/immigration. Okay, so these next three slides are tips and information to assist you with your outreach work. It's not necessarily information uh, to be shared with the public. We just wanted to share it with you to ensure that you are successful this grant year as you're ramping up your outreach work on work rights. So as it relates to investigations, the New Jersey Department of Labor receives thousands of wage and hour complaints each year. Not all complaints will be handled in the same way, so that's important to highlight. A notification of investigation results could take weeks or months, so it's important to know how long, if a complaint is filed, how long a worker may have to wait to see some kind of results or get an answer on their complaint. The New Jersey Department of Labor has the ability to issue stop work orders on job sites when there is strong evidence of workers being exploited. So there have been 168 stop work orders issued since 2019 by the New Jersey Department of Labor. The New Jersey Department of Labor is also implementing a strategic enforcement approach to target high violation industries with low rates of complaints. Current campaigns are in the drywall construction and laundromat industries. Um, and our How to File a Complaint brochure was recently updated. We know providing more detail on the investigation process was important, and it will be available in Spanish soon, and we are working towards additional languages for folks. Ways to support workers. So there are a number of ways you as care grantees can support workers around their work rights and accessing them. You can get to know the myworkrights.nj.gov webpage. All the information and additional details on the presentation today are on that site. You can help workers prepare to talk to their employers about their rights or speak to the employer on their behalf. So I know a lot of the grantees are already engaging in this work. So it's often, helpful to sort of speak to a worker about how to approach their employee, or, if you're willing to do so, speak to the employer on behalf of that worker. You could provide handouts to workers that they can pass along to their colleagues or their employers. And again, that can be found at nj.gov/labor/care. You can help a worker file a complaint and submit strong evidence. Again, you can't file on their behalf, but you can help them file a complaint by themselves. You can share information on confidentiality and how to file anonymously, and you can encourage workers to provide their contact information on the complaint. You can host in-person interviews with workers to aid New Jersey Department of Labor investigations, and you can explain protections for immigrants and New Jersey Department of Labor's immigration relief options that I covered just before. We're working on resources to help organizations better support workers to submit complaints, and we hope to have those ready soon to share with you. Finally, there are ways to support employers with wage and hour laws as well. Again, you can get to know the My Work Rights webpage. You can help them understand the laws and develop an earned sick leave policy. We could help an employer develop their policies so that they're accurate. You can share New Jersey Department of Labor resources, including our Employer's Guide to Wage and Hour Law handout, which can be found again on the Care Grant webpage. So um, nj.gov/labor/care. You could provide them with mandatory workplace posters in their employees' languages. And again, you can access those on nj.gov/labor/employees. And you can connect them with Chamber of Commerce or business associations dedicated to helping keep employers informed. And then finally, we just have some of our outreach materials here, which I'm sure many of you are familiar with. We've got some of our earned sick leave memo here, just to educate workers again about, what they're entitled to. So the workers earn 1 hour of sick leave for every 30 hours worked, up to 40 hours per week. We have our little emoji there, which we internally call snotty. And we have a bunch of other handouts on our earned sick leave law. We have a brochure here on, your work rights brochure, which is a small square, like pocket-sized brochure, which covers at a very high level some of the wage and hour topics that we discussed today. And then we have handouts on how to file a complaint, a wage and hour complaint if work rights are being violated, information on temporary workers' bill of rights, and then we have a longer handout on sort of an employer's guide to wage and hour law, which we can be shared with businesses and employers. So I think that's it for the training I have. If I think we're going to go into a Q&A portion now. So let me just come off my screen real quick. Great. I don't know if hopefully my colleagues will be keeping an eye on the chat. I don't know, Rebecca, if you want to take over for the Q&A portion.
Yeah, please put your questions in the chat. You're also welcome to get off mute. I also just wanted to mention that we have our new team member, Kim King Webster here. She used to be a wage and hour investigator. Now she's in charge of outreach at the department for our office. So she's going to join me in answering any of your questions because she's quite the expert. But yeah, feel free to come off mute or put your questions in the chat.
Uh, with the tips minimum wage, can you hear me? This is Hugh.
Yeah.
Yeah, how do employers typically monitor whether their employee is getting the minimum wage, or how do they monitor how much extra is made in tips? Because that tip part is generally fairly informal, and how can I guess I'm thinking from the employee point of view, how do they argue I should be getting more if it's this sort of gray informal area and no one's really tracking it, or do they generally track it? How does it work?
You want me to take that?
Yeah.
It is tracked. On a pay stub, the employer will indicate that the employee is receiving like $5.26 per hour. And then they have informed the employee that they will pay the difference as a tip credit, and that will equal $15.26 or whatever the minimum wage is for that particular year. So it is tracked. So the employee does know that they're making minimum wage. So they make the 526 plus tips is what the employee is receiving.
Mm.
Does that make sense? And usually you'll see that in restaurants more than anything.
But if I'm just wondering if the employee says, I'm
Now they can make over that, excuse me.
I'm not making the nine. I don't remember the exact amount, the nine or whatever it is extra
87,
they have
yes.
to. Yeah.
So
It's sort of all the tips say are typically put in a jar or something.
that's a different situation.
How do they argue with their employer? Look, I'm not reaching that minimum wage.
So that's a different situation. If tips are put in a jar, that's called pool tips. And pool tips, all tips are for the employees only. So if it's pool tips, those tips have to be or are distributed to the employees that are working at that particular time. Management cannot participate, of course, in those tips at all. So that's not listed. That's a different situation. That's pool tips. So if you and I and four other people are working at the end of that shift, we divide that tip amount up. If I'm the only person working, then I would receive that tip. If that employee makes over a certain amount by law, and I'll get back to you on that, what that number is, then that must be reported in a monthly basis. Then they have to report. The employer is obligated to report. But if you're talking about a tipped employee, let's say that's a waitress or a hostess, or server, excuse me, that's a server, then that particular person, they know that they're going to be paid tips plus their their cash wage amount plus tips. So that would be 526 plus the tip amount. And what they're doing is looking at the total hours worked, right, divided by the gross amount. And that's how they can determine if they made 1513 at the end of the day per hour. Does that make sense?
Yeah. Yeah,
If
that's
it
great.
doesn't,
Thank
we
you very
can
much.
definitely follow up with you offline. I'll be happy to do that if you leave your information in the chat.
I do think you're making a good point that it is quite complicated, and it can be very difficult to figure these things out. And yeah, it's never black and white for sure.
But we're here at the Department of Labor to support you in wage and hour. So if you have any questions, you can always call wage and hour and they will come in and they will help you and we will help you.
All right, thanks.
You're welcome.
Julie, I'm not totally sure if I understand. You're asking, why did federal law have exempt, non-exempt employees? It's a federal law that some employees can be exempt from overtime. There are requirements you have to meet under the Federal Fair Labor Standards Act to be exempt. That's that you're paid salary. There's a minimum weekly salary level you have to meet, and there's certain job duties that are covered. That's just the federal law. If you want to explain a bit more about what you're asking, I'm happy to try my best. Though this is a federal law, so we are not going to be the experts in it, but we're happy to take a stab at it.
Are you there?
No. Just wondering why it exists. That's a great question. I'd have to do some research on that. Yeah, I'm not sure why it exists. I think maybe many salary employees just naturally, because they're not paid on an hourly basis, like it's probably more difficult to track overtime and when you're working, but I'm not totally sure on the history of it. The Federal Fair Labor Standards Act is a pretty old law. I'm sure there's something. I'm sure capitalism has to do with it. Okay. What other questions do we have?
I'll also just say that we have a survey, like we always do, about our trainings, and I will drop that into the chat. We just ask that if you could take 5 minutes to complete it, it really does help us think about how to meet your needs in terms of designing trainings and offering resources and supporting you all to do the outreach work. So I'm going to drop that in the chat now. So yeah, if you could take 5 minutes to complete that, it would be much appreciated so that we can continue to, help you all, do your outreach work. And yeah, just feel free to drop questions in the chat. Our team is going to hang out here like we usually do and just answer any questions. You can drop in the chat. You can just come off mute. We'll hang out for a bit and try to answer any questions that you have about the training or any scenarios that you may encounter. We're happy to try to tease them out a little bit. So yeah, we'll be here.
Complaints can be anonymous, but they're certainly more effective when you include contact information. Oftentimes investigators need to follow up, and if they cannot follow up and get more information, then there's not much you can do with the complaint. So we do encourage you to understand like all the confidentiality protections that David shared in the PowerPoint to hopefully assure workers that it's okay to include their name. But of course, we know there's always risks, and that's a calculation workers have to make. If you're asking if they can disclose at some point, it's like if you initially file anonymously, there's no way to follow up with that complaint. So you could then maybe file a complaint later with your name. But you would have to initially disclose your name. That would be right, Kim, right?
That they do need to disclose their name. That would give them a better chance of getting the situation resolved. But if they don't disclose their name as an investigator, we do everything that we can to resolve that case and try to find to ensure that complaint is substantiated. So we'll go, let's say, for instance, we'll pick 4 names and we'll give them to the employer. And of those 4 names might be that complainant name that did not want to really be revealed, but it's a group of names, and we'll ask for information. And at that point, we'll go and we'll dive in and we'll look at the information of the records very carefully. And at that point, we'll try to see if we can substantiate the information, but we would never pull out that individual name independently. We may include it in a group of names in order to get to the bottom of the situation. Does that make sense? So that particular person is not disclosed at all. They're in a group. So that employer does not know if it's Mary, Jane, or Sam. They do not know. They're just providing the information. But you are right. It's best to give the name in order to get a case or a claim substantiated and workers receive the benefits or back wages that they're due. It's hard to give you back wages if we don't know really who we're looking to give them to or the situation. Does that make sense?
Thanks for adding all that information, Kim. Yeah, and as Kim said, they won't go in and, as said in the slides, they're not going to go in and say like a complaint about this specific thing is filed against you. It's we keep it as high level as possible.
Right.
Julie, would you mind just putting the name of your organization in the chat, and where's the wage and hour hotline number for support? The slides will be shared, so you'll get all that contact information. Any other questions? Oh, Viet Lee, great. Good to see you. We love Viet Lee. Okay. Any other questions?
And also, I do want to add something in regards to the anonymous and the complaint. We, as an investigators, we do interviews. So we'll go out and interview the employees, and we'll ask about that question or that scenario or complaint that that individual anonymous person gave us. And we'll look to find and see if that's true among other employees. So that's another way that it can be followed up to see if that's actually happening.
Exactly. I do want to reiterate, because we get thousands of complaints every year, we have to handle some differently. So like, as Kim said, you just have the best chance of being able to resolve it in a way that's positive,
equitable.
Like if you include contact information. But I totally can understand the fear, the concerns. I don't mean to minimize those at all. But we just want to be straightforward with how to, best resolve these situations. And David mentioned we are actively working on a resource that will help you guys support a worker filing a complaint and give you some more written insight into the investigation process. Some of you have provided feedback on that already, and we hope to share that soon. That's the include individual leave their employees for this type of. That's Raul, I'm not exactly sure what you're asking, but yes, if you think you're misclassified as a 1099 when you're really an employee, you can file a complaint. It's like, I think it's like
Mhm.
an option to select on the complaint
Mhm.
form, that's the complaint you're filing. Jessica, I do not have, current wait times, unfortunately. Every complaint is handled based on the content of the complaint. So, and based on severity as well. So it's not like, I don't think it's not like an unemployment application where we can estimate an average wait time. It really does depend. Would you add anything else, Kim? I think that's the best we can say right now, right? There's nothing.
Right. And the detail, the more you tell us on the complaint, the better, you know, the better chances. Well, we're going to get to all of them. It just depends on what group of people, what